and then indeed we probably have unanimity. Thank you.
For Stuart Nash.
Yeah, thank you very much, Mr Speaker. There are 2 points that I would like to raise a couple of points on and perhaps ask the Minister a couple of questions on. Start on Clause 201, its power to clear the court. Now, it states in Clause 201 that the court may make an order excluding from the whole or any part of any proceedings in respect of an offence all or any persons. And what it does, Mr Chair, is it lists the people that are allowed to stay in the court after an order to clear the court has been given. Now, the question I ask is there is an exception for members of the media. So what the bill actually says is that when the court or when the judge declares that the court must be cleared, media are actually allowed to stay in there. Now, except if it relates to the security of the defence of New Zealand. Let's park that to one side. And let me give you an example. The court must be cleared, Clause 203, the court must be cleared when a complainant gives evidence in cases of a sexual nature. Now, I understand that and I completely agree with that. I think anyone with a heart would agree with that. But I suppose my question comes around to the point is why always keep media, or why put in legislation that the media is allowed to stay in some of these cases when the complainant may in fact find that the presence of media is intimidating to the point where they don't give evidence. Now, there are many cases, there are a number of cases that I'm aware of, and I think we're all aware of, where media has stayed in and these cases have been reported. And I wonder where that line is, Mr Chair, where that line is with the society's right to know versus the right of the victim or the complainant. Because I would argue that in some cases, certainly in some sexual cases, the right of the victim or the complainant overrides or should override society's right to know what happens in that trial. So that's a question. I wonder why the media is there specifically being given an exemption to that. The other one is I'd like to talk about is clauses 204 through to 208, and this talks about the suppression of the identity of the defendant. And this includes the identity of defendants in sexual cases and children, or in fact where the judge determines that it is not in the public good. There are a couple of questions I've got here. First of all, in the initial bill, what it said is the court may make an order forbidding publication of the name and any other identifying information about a person. Now, for some reason, the committee changed that to say a court may make an order forbidding publication of the name, address or occupation of a person. And I would have thought name, address or occupation is simply a subset of any other identifying information. And I don't know why they narrowed that right down from any other identifying information, because I would have thought that if there was a risk that identifying information other than name or address or occupation, then in fact someone whose name was suppressed could be identified. And it's a question I have around that. The other thing also is it says the court may make an order under subsection 1, which I sort of read out, only if the court is satisfied that the publication would likely to cause extreme hardship. Now, what is the definition of extreme hardship, Mr Chair? I'm not too sure. It's not defined in the bill. Extreme hardship for one is not extreme hardship for another, and we have seen a number of high-profile cases, or high-profile people, I should say, in this country receive name suppression due to the fact they're a sports person or high-profile business person, and yet others, which could well be identified within their circle of friends but aren't considered high profile by the media or by the court, do not get name suppression. And where is that line? And I have a huge concern about this. Again, it comes back, of course, to society's or the community's right to know versus the rights of the complainant, and I understand that. But there has been huge debate around this name suppression and where is the line drawn. I mean, if you're an All Black, not you, Mr Chair, if the defendant is an All Black, is that enough to cause... It could be. No disrespect intended to your rugby playing skills, Mr Chair, but to cause extreme hardship. And it lists, under 204.2, it lists a number of times when the court may make an order to suppress a name. And like I said, cause extreme hardship. I understand that, but what is the definition? Another one is cast suspicion on another person that may cause undue hardship to that person. Now, I would have thought that that's a reason to actually name a defendant. as opposed to suppress their name, because what has often happened, and we've seen the case recently, Mr. Chair, thank you very much, where a high-profile person has been given name suppression and others have had to come out, and this is normally sports or business, others have had to come out and say, it's not me, don't cast aspersions in my case. I have not done this. So in fact, there's a case recently where a high-profile rugby player has written an autobiography, and he's actually put in that autobiography a case where he was sent to court, and I think he was tried, I'm not too sure, and he did that because he said he didn't want aspersions casted on other members that he played with. So what we get here is cases where suspicion is cast on other people simply because there has been a name suppression. And I wouldn't mind a definition of address. Now, what is the definition of address? It sounds pretty simple if you're a postie, of course, but is address, does that mean your city? Does that mean your suburb? Does that mean the road you live in? And remember, the media are allowed in these trials. So are the media allowed to say, Mr. Businessman from Ngāpuhi Road in Remuera or Auckland has name suppression? Now, if that is not defined as address because it doesn't specify that person's exact house, then it is it is easier for an investigative journalist or someone who has a wherewithal to go through any sort of role and determine, okay, it can't be 95%, therefore it must be 3, 4, 5 people, due to the fact that there's only 5 people that fit the profile in Ngāpuhi Road, in Remuera and Auckland. So the definition of address would be good. And this is why I have concerns, or I'm unsure why the committee went from any other identifying information, crossed that out, and simply went to address or occupation. So there are a couple of questions there as well. The other thing is, one of the areas where you can have name suppression is it says, create a real risk of prejudice to a fair trial. Now, if it is a jury trial, then obviously the jury is going to know who this person is anyway. If it is a trial by media, then, well, obviously, if it is name suppression, then the media isn't allowed to put this information out there. But in a lot of cases, the name is out there, and so you could argue, and we're seeing this at the moment in the States. Michael Jackson's doctor is being trialled by media. It's a shame, but this is the way it works. Where, again, does the question I ask is, where is that line between the community's right to know and the victim's right or the defendant's right to a fair trial lie? And I'm not too sure, and that is why I have major concerns about identity suppression. There are cases, of course, where it is an absolute given, and my personal view is it relates to children, of course. If a child is a defendant, then we don't want that person's name released in any way, shape or form. And I can suggest other areas where perhaps it is a trial of a sexual nature, and it does outline this here, and I completely agree with it. Clause 205, automatic suppression of identity of defendant in specified sexual cases. Makes complete sense. But these other cases, I have concerns, and I just wonder if the Minister can just sort of allay my fears. There may be a very good reason for this, as well as the concerns of many others, because it has been a debate that has gone on the blogosphere, through the courts actually, as well as in society over the last couple of years. And again, I come down to clause 209. It's a suppression of evidence and submissions. We come to that undue hardship test again as well. And I wonder, is there an undue hardship test, or is undue hardship that a concept that will be determined by the presiding judge? And if it is, then this may mean that undue hardship is in fact a term that, well, I don't know, will be open to legal precedent as opposed to something that is defined by legislation. And I just wonder if there perhaps should have been a definition of undue hardship, because, as I say, it is a relative term, but I think there maybe should be a test in there, or there could have been a test that outlined that. That's all at this point, Mr. Chair, but there are some questions there that I wouldn't mind just a little bit of a stare on. Thank you very much.
The Honourable Simon Powell.